This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I am super grateful for you. If you haven't already subscribed, shame on you. Subscribe. If you're on YouTube, well, yeah, I guess if you want to be on YouTube, that's fine. Make sure you click the bell and you'll know about, hopefully you'll know about the videos as well. They are standing on my head at YouTube and shadow banning the tar out of me. So I do urge you to check out both X and Rumble. All of my videos are on both of those places, and neither of them censor me in any way. So X and Rumble are actually just better places to go. If you'd like to support the channel, you can do that at GunGuyTV Crew. You can get exclusive content you can't get anywhere else. And you can sign up easily. Just go to GunGuyTVCrew.org or go to the link in the description. Or if you're already on Patreon or Locals, just search for GunGuyTV. All right, we're going to talk about the Rahimi decision with Chuck Michel, because it's a lot of bandying about whether that was good or bad or what. Let's find out from Chuck what the real answer is. Chuck, thank you very much for joining me again. I really appreciate your time. Love the CRPA shirt. I got to get one of those. That'll be kind of cool. I got to drive all the way to Fullerton to get one. Oh, I can order it online. Never mind. All right. Well, Rahimi finally dropped a few days ago, and there has been a lot of bandying about is it good? Is it bad? Is it kind of in the middle? You've had an opportunity to exhaustively study the decision. What exactly did Rahimi end up doing for us or against us or whatever? I'm trying to figure out if it's helpful or not.
Well, first, let me clarify. I have not had a chance to exhaustively read the decision. It's over 100 pages, and there's like a half a dozen concurrences, and then one dissent from Justice
and you
Thomas.
know, now that you say that, I have read them all. Not exhaustive. I did read them. I mean, I'm not an attorney. I found the concurrences very interesting because it was almost like they had a meeting in which Roberts said, okay, I'm going to write this decision like this because we can't have this Rahimi guy go scot-free, and we can't have him have guns. He shouldn't have sharp implements. We don't want him to have guns. And you, Gorsuch, you're going to write a concurring opinion that tightens this up. And Kavanaugh, you're going to write one that tightens this up. And Connie Barrett, you're going to write one that tightens this up. Okay, everybody know their marching orders here? All right, go. It's really kind of funny because as I read the concurrences, it's as if the concurring justices were going out of their way to tighten things up because the Chief Justice really didn't do so in the decision. Now, I don't know if they coordinate things like that.
They were all anticipating, you know, how the Chief Justice's portion, his ruling, would be interpreted by primarily the anti-gun attorneys general and the lawyers at Everytown Law that Bloomberg pays to coach anti-gun owner states on how to pass stuff that get away with passing stuff that infringes on the Second Amendment. So,
do you feel like they were effective in kind of forestalling that a little bit?
Somewhat, but the main problem is, and everybody needs to recall the two-step process in evaluating the constitutionality of a gun law. First, does the text of the Second Amendment cover it? In other words, is the right to keep and bear arms implicated by the modern law? And almost any bearable arm is. That was one good thing they clarified. Any bearable arm is covered by the Second Amendment. And other cases have clarified that related conduct, like buying or selling or fixing or hunting or target shooting or whatever, that's all covered too. So one of the things that the concurring opinions did is kind of clarify some of that, because they're anticipating how this Rahimi decision is going to be misinterpreted. Now, remember, the second step is there a historical law that's analogous to the modern day law that would show that there's a historical tradition of this kind of law? Would the founders, the drafters of the Bill of Rights, have tolerated the modern day law, notwithstanding the Second Amendment? And that's kind of the battleground now And the problem in Rahimi, to the extent it is one, and I don't think it's that big of one, although I know that Thunberg's lawyers are going to try and make it one, is that they relied on two historical laws. One is a surety law, which is basically if somebody looks like they're going to cause trouble, they have to post a bond, basically, and put up some money that if they get in trouble, they lose. And they have to get references and things like that so that they basically vouch for their character. And the other one was a series of laws, a number of laws, that prohibited going around the countryside terrorizing people with guns. Now, there were a lot of those laws around 1791 and thereafter. And so the court said that's enough because those laws were designed to disarm dangerous individuals, not a class of people, dangerous individuals, and they temporarily disarmed them. So that was enough to uphold a law that is designed to disarm one dangerous, in this case, the dangerous individual, Mr. Rahimi, because he had a restraining order against him. And he's not the poster child for the gun rights movement, of course. He's not really a good guy, and he deserved to be disarmed. But the problem is that the court, in loosening up the connection, or at least this is what the states are going to argue, that the court loosened up the connection between the historical law and the modern day law that needs to exist in order for the modern day law to be justified and constitutional.
Now, in the surety laws, one of the things I think it was brought up either in the body of the decision or in the concurring opinions, I don't remember which, is the fact that even when you had a surety law, if you were disarmed, and even if you were disarmed for any other reason, you could petition to have your arms back because you needed them for self-defense.
Yes.
So I thought that was very interesting. So as we look at that historical analogy, if you want to call it that, even in those cases, these people were not wholly and completely disarmed. They could petition to get their arms back if they needed them to defend themselves.
Right.
I thought that was interesting. I don't know if there's...
Yeah, those were all temporary measures. And that's what a restraining order is, too. It expires. And that's one of the interesting things about this is that it may make California's law... They also required due process for Mr. Rahimi. In other words, he got a court hearing. He got notice and an opportunity to be heard to contest the restraining order. And that restraining order is not indefinite. So in California, there are procedures where someone can go in and get a restraining order against someone, and that person loses their gun rights without a hearing, without notice and opportunity to be heard. And it can be open-ended extension on those things that go on forever, no matter how non-dangerous that person may become. So there are some California laws that are now vulnerable, and also some California policies. They made clear in Rahimi that responsibility or irresponsibility is not the test for disarming someone. It's dangerousness. And some of the cities like LA County Sheriff are denying people CCWs, licenses to carry in public, based on the Sheriff's Department determination that they are irresponsible because they got a gun stolen or they had a restraining order 10 years ago. So there's a silver lining to some of this stuff. We lost a battle in Rahimi, but we by no means lost the war. The precedent that comes out of Rahimi, although the Bloomberg lawyers will try and coach the states that are against gun owners to use it to their advantage, it's not really as bad as they're going to make it out to be.
Do these things also apply to things like red flag laws where there is no due process? I mean,
yes,
they just show up and take their guns.
Yes. Gun violence restraining orders. Yes.
Are these now more vulnerable in places like California than they were before because of Rahimi?
Yes, because Rahimi dealt with, it said that the reason that the restraining order against Mr. Rahimi was enough to disarm him was because he had an opportunity to be heard, due process, and it was temporary. So any disarmament provision, restraining order or GVRO or whatever, that disarms someone without those protections is vulnerable.
When you look at the concurring opinions, I was curious about this because I don't know how it works. Are concurring opinions precedent, or are they simply persuasive? In other words,
they're persuasive. The only real binding, I mean, they're maybe like the most persuasive type of ruling next to the mandatory authority that is the actual ruling that everybody signs on to. So they're all considered.
Are they considered sort of part and parcel of the decision because they concurred? Is that how it works?
Yes, but it's one judge. It's not all 8 or 9 judges saying it. It's one judge saying it. So it doesn't. It's not like the force of the entire court.
Does Thomas's dissent, which was kind of like taking a law class, I found it fascinating when I read it. He's very detailed there. Can any of that be used for us, or is it is that persuasive at all, or is it just
things that he said can be used? But remember, what the test that's supposed to be applied when you're trying to figure out whether a historical law is analogous enough to a modern day law to justify that modern day law is supposed to be, the question you're supposed to ask about that historical law is, why did they do what they did, and how did they do what they did to address the problem? So the why, to disarm dangerous people, everybody pretty much agreed on, but the how, which was surety laws and statutes against terrorizing the countryside, that's different from a restraining order. And Justice Thomas's big point was, this guy hasn't been convicted of any crimes. So, you know, it's not the same how. It's not, they're not, the historical laws did not go about disarming people in the same way. They may have had the same reason, disarming dangerous individuals, so the same why, but not the same how. And that's Justice Thomas's test from Bruin. The historical law has to be for the same reason and in a similar manner, not a twin. Nobody ever said it had to be an identical twin, but something that shows that they did it for this reason and in this way, and that's similar to the reason that they're doing it today and the way they're doing it.
It seemed to me, in reading the dissents, that with the sole exception of Justice Jackson, the other dissenting judges may have stuck their foot in their mouth, because it seems to me that they agreed that the Second Amendment right to bear arms is a right, and that
yes,
Heller and McDonald and Caetano and Bruin are the law of the land.
Yes.
And I thought that was interesting coming out of them in dissenting opinions.
Yeah, the Hail Mary pass that the United States Attorney was trying to get here was to strike down Bruin or break down Bruin completely. They did not win. They did not get that. They lost on trying to be able to disarm irresponsible, quote unquote, people, and that we can only disarm dangerous people. And they lost on trying to say that he wasn't part of the people, to try and basically shove stuff back under the textual portion of the analysis rather than the historical portion. You know, and that's the game they're playing. They don't want, you know, keep and bear arms. Well, what's an arm? The people, the right of the people. Who are the people? And they're saying, you know, magazines are not arms. Assault weapons are not arms that are protected by the Second Amendment. There's nothing in this opinion that buys into any of that. So really, it was a lot of reiteration of Bruin and Heller and Caetano and McDonald in the concurring. Nobody dissented other than Justice Thomas in the concurring opinions, but those other judges who are known to be anti-gun owner did try and, you know, they begrudgingly acknowledge that Heller and Bruin are the law.
Well, and it seemed like Thomas's big issue, as you say, was more the how. It wasn't necessarily, I don't think he disagreed with necessarily that Mr. Rahimi shouldn't be harmed, because he really shouldn't.
No, he agreed.
But he agreed with that. I think it's how they got there that he had problems with, because he's seeing what you and I are seeing, and many others, is that they've sort of loosey-gooseyed the historical analysis question a little bit. How much trouble do you think that's going to cause us going forward?
Well, it's already causing us trouble. The California Attorney General already submitted a letter to the Ninth Circuit en banc panel in the Duncan case. That's the magazine challenge. basically saying that any of the flimsy historical analogs that they tried to push in the Duncan case are now enough, and it's complete poppycock. Oh, by the way, all the analogs they have for particular types of armbands are all outliers. They're all like one-offs. The ones that were relied on in Rahimi were common, but a lot of the laws that the states rely on to try and justify modern day historical laws, they try and use to justify modern day laws, are, in some obscure town or city somewhere in one place. It's not like a universally accepted or common law. So those are not, and Heller and Bruin both rejected those outliers, said that's not grounds to say that something would be tolerated today. So just remember, all this is about is the larger battle here is over originalism and the approach to constitutional interpretation. And they want to go, the originalists want to go by what the founders intended when they wrote it. What did we agree to when we wrote the Constitution? If it's not clear from the language, then you have to look at, basically you're looking at legislative intent. And so what was the intent of the legislature when it wrote, of the founders, when they drafted the Bill of Rights that included the Second Amendment? And so the progressives want to have a living Constitution. They want to reinterpret the Constitution in a way that works for their goals. And that's just the loosey-goosey kind of thing that leads you down the road to tyranny, because you can interpret any provision of any document, any statute, any way you want. And by the way, that's best illustrated maybe by Cargill, which was another Supreme Court decision that came out this week that dealt with the ATF's change of opinion on whether or not bump stocks were illegal machine guns. And there's some good news out of that one too. Cargill, the court in Cargill made it clear that semi-automatic firearms are not machine guns, and semi-automatic firearms equipped with some device, in that case a slide bump stock.
Yeah, bump stock, right.
Are not, that doesn't turn it into a machine gun, as that term is defined by federal law. Federal law says a machine gun is something you pull the trigger once and it keeps firing. A semi-automatic, you have to keep pulling the trigger. Everybody who has ever shot a gun pretty much knows that, but some bureaucrats and anti-gun rights groups don't, and they've been trying to blur the line between semi-auto and full auto. In the Cargill case, in the Illinois semi-auto bans, because they want to just group, they'll keep going backwards.
So it seems to me that Rahimi was a setup. I think we all knew it was a setup.
Yeah, it was.
This was the Merrick Garland trying to stuff a situation into the Supreme Court where they had to blow up Bruin. I mean, I think that was their goal, and obviously, as you say, they didn't achieve that. That being the case, I mean, it seems to me the court did a pretty good job of walking the tightrope there, and in the concurring opinions, cleaning up things. For example, you mentioned the process and originalism. I think both Amy Coney Barrett and Brett Kavanaugh covered that exhaustively in their concurring opinions, where Kavanaugh even went into this is what originalism means, and this is how the process works. And I think Amy Coney Barrett took it from a slightly different angle. So I agree. I don't think they achieved much. But do you see the Supreme Court taking an opportunity in the future to tighten this up even more and sort of recover from this? That
is the big question. See, there's at least 4 cases, actually, I think more than that, pending in front of the Supreme Court, asking for the Supreme Court to grant certiorari and review those lower court decisions. They're in the Supreme Court right now, and the Supreme Court has punted. They've postponed deciding whether or not to take one or more of those cases for like a month, and in some cases longer. So we're going to hear something either tomorrow, Thursday, Friday, or Monday, as the Supreme Court wraps up this session for this 2023-2024 session. They will or will not take those cases. And so depending on what those really, you're exactly right. They know that they've left some questions unresolved with Rahimi and Bruin and Heller. And so they should take one of those cases. There's semi-auto cases out of Illinois. There's a sensitive places cases out of New York. They should take those cases and now straighten out how that analog applies in other contexts.
What do you think they're going to do with Chevron when it comes up?
With Chevron deference?
Yeah.
I think they're going to get rid of it, mostly. Chevron deference is courts are supposed to give deference to the executive administrative agency, their interpretation of a statute. And this is not just guns, but that was sort of what happened with the Cargill case. The ATF reinterpreted its position. For years it said bump stocks were legal. Then it changed its mind. And then it wanted the court to defer to its opinion. You know, never mind, all these opinions are politically motivated. They're never going to find a government lawyer who says, oh, no, that statute doesn't give us authority to do what we want to do. So it's totally biased, and they don't deserve the deference, the administrative agencies, to interpret a law the way they think it ought to be interpreted, because they'll always say, we interpret it to give us more power. So the Chevron deference doctrine, I think, is on life support. We'll see what the Supreme Court specifically says, but there's plenty of reasons to get rid of it and just let a judge decide what a statute means, and don't give any you can listen to both sides that say what a statute means.
Can you define what does deference mean in that sense, in the legal sense?
Basically, if you're not sure, you defer to the administrative agency's interpretation. If there's any doubt, you say, okay, well, tie goes to them.
No wonder they win all the time. Jeez.
Yeah, that's why you can't fight City Hall. That's part of the people don't understand. I've been butting heads with government officials for 30 years. They get a lot of deference. They get a lot of support from the courts. They get a lot of sometimes it's very hard to win, even if they're dead, even if the government is dead wrong.
If you look at that lady with the scale and the blindfold, it seems like the scale is already tilted toward them to a certain degree, and that's the problem.
When you're up against the government entity, it is.
Yeah, let's hope the court does that in. If you were to sort of score it on the Rahimi decision and give it a percentage either way, how much do you think it helps us, and how much do you think it hurt us?
Oh God, that's a tough one. I would say it helps.
I'm famous
us.
For those.
It helps us in very different ways from where it may hurt us. It helps us by clarifying and reiterating Bruin and Heller. It helps us by getting rid of this notion that you can disarm somebody who's irresponsible. It helps us by showing that there's no two-step test, at least the way they applied it. It's implicit. And it may hurt us because of the way it's going to be misinterpreted by the way they used historical statutes to justify a modern law, and may have loosened up the connection that should be required to use those historical statutes to justify a modern law. But we have plenty, if the courts listen, we have plenty of clarifications there that show that Rahimi shouldn't hurt us at all. One important thing to remember, though, is in some of these hostile circuit courts, like Ninth Circuit, Second Circuit, they don't care that Rahimi gave them this little excuse. They were going to find flimsy connections justified modern laws anyway. So that brings us back to the Supreme Court's got to take another case, got to clarify it in a different context, and hopefully they'll do that in the next couple of days with some of the cases that are pending in front of them now.
If the Supreme Court tightens things up and the Ninth doesn't care, I mean, at what point does this end?
At the point where the Supreme Court doesn't leave them any wiggle room. And right now they haven't done enough. They need to do more. They need to issue more decisions that clear up every little place where the Ninth Circuit or the Second Circuit or certain judges in those jurisdictions try to wiggle through. Once they shut those off, that's where it ends. They're not going to say, I mean, if the Supreme Court says, this guy's got to pay that guy $100,000, the Ninth Circuit's not going to say, no, they don't. They're not. If there's clear instruction, the Ninth Circuit's not going to. But when they leave that ambiguity. And it's not even ambiguity. I'm sure the Supreme Court justices write these opinions and they say, we're being about as clear as we can be. And then you get a bunch of lawyers on Bloomberg's payroll and a bunch of judges who are biased against gun ownership and maybe in favor of the government. And they find ambiguities that the Supreme Court probably couldn't have anticipated.
Okay, last question, because we are in an election year. Chuck, how important do you think to our justice system, our court system, is the coming presidential election, and why?
Well, because the Trump judges are the only ones that are saving us in the Ninth Circuit. If you want a rigged deck, same with Cargill. Justice Sotomayor says, when I see this gun being fired with a bump stock, it looks semi-automatic, and it looks fully automatic. So if it looks like a duck and quacks like a duck, I call it a duck. Well, no, that's not how you read the law. You don't say close enough for government work. You have to. Bottom line is, if you want judges who are going to bend over backwards to uphold government policies that are unconstitutional and should be held to be unconstitutional, vote for Biden, because he'll try and stack the court. And that's the long game they're playing. They want some of the conservative justices on the Supreme Court to retire so that Biden gets elected and can appoint liberal justices. But it trickles down from there. All the circuit court judges, all the district court judges, depending on who appoints them, often have a perspective that matches the policy of that administration. And Trump's got a lot of warts, but his policies, are on guns and the border and the economy are better on everything. It's really not just the justice system. It's the entire America. I saw a Trump commercial the other day said, this is the most important election in our history. We're either going to make America great again, or we're either going to save this country or we're not going to have a country. Because there are people, many of whom are being manipulated or steered by folks with a much larger agenda than just guns, to take away our freedoms, our individualism. They want, socialism or something more extreme. It just doesn't get any more important than voting this year. And I know I'm voting for Trump. I don't like him personally. He picks fights he shouldn't pick, but he makes policies that will make this country better.
What do you think about third-party candidates? People say, well, I don't like Biden, but Trump irritates me, so I'm going to vote for Kennedy. Because...
Well, is Kennedy pulling him away from Democrats or from Republicans now? Because if he's pulling him away from Democrats, then I like him.
And I don't know the answer. I do know that in the past I voted for Ross Perot once as a third-party candidate, and I learned my lesson, and I've never done it.
It's generally a waste of
vote. Much as
vote.
I absolutely hate our two-party system, and I think it needs to change.
Oh yeah.
I don't think this is the year to try to change it. I really don't. Pick the one whose policies are better, and ignore the individual if you don't like them. It's the policies that you're voting for. I agree with you. Well, Chuck, is there anything we should talk about that we didn't?
No, but you should have me back if the Supreme Court does something tomorrow or Thursday or Friday or Monday.
Yeah, I'll be sending you an email 6 seconds after I find out about it. All right, man. Have a great week, and thanks for coming on.
Thanks, Joel. Always a pleasure.
Thank you very much for watching the entire video. I'm super grateful for you. Have a wonderful week. Make sure that you subscribe at both X and Rumble, or one or the other, whichever one you like best. And again, if you want to support the channel, you can take a class with us at Practical Defense Systems. That's easy. There's a link in the description. Or you can join GunGuyTV Crew at GunGuyTVCrew.org, or on Rumble or Locals. On Patreon or Locals. Locals is better because Locals doesn't censor me at all. They're part of Rumble. All right. Have a great week. Thank you very much for all of your support. Wherever you go, whatever you do, stay safe.